Welcome once again to Lehto's Law. Here's Steve Lehto.
Got a story here sent by a bunch of people, including Caleb. Thank you very much. British Columbia ruling says note on dinged car was binding contract between two lawyers, and primarily because the two people involved in the story are in fact lawyers. Okay, it wouldn't make as much sense otherwise. But this could happen in America. This right here, the distinction between this happening in Canada or happening in the U.S., I think could have happened here just pretty much the same way. The decision issued recently says the note was a settlement agreement that couldn't be changed without both parties agreeing. The Canadian press ran the story written by Daryl Greer. BC's Civil Resolution Tribunal says a note left on a car with a dinged door was a binding contract to pay repair costs. Some people are going to say, Steve, don't contracts need to be signed by both parties? No. So the decision says a lawyer was being dropped off in a parking lot at an event in September 2023 when she dented a fellow lawyer's car's door. Okay? She left a note saying, I dinged your back passenger door, adding that she was happy to pay and left her phone number. Now, that is a writing. It was in writing. We don't know if she signed it or left her name, but the point is that she created a writing in which she said, I did it, I'm happy to pay, and put it on his car. The ruling says that she later said she'd pay the repair bill after appraisal, or pay $2,000 with no appraisal, or that the man should file an insurance claim. So the man did file an insurance claim, and it turns out the repair bill was $2,231. So the Insurance Corp of BC paid the $1,731, and the man then says, you owe me $500 to her. And she said, wait a second. That wasn't our agreement. I said I'd pay you $2,000 with no appraisal, or I'd pay the repair bill of $2,231, or you file an insurance claim and I pay nothing. But see, that I'm not quite sure why that even makes any sense. Because if she's willing to pay $2,000 with no appraisal, why isn't she willing to pay $500? I know some people might say, but Steve, without an appraisal implies that there might not be insurance involved or something. And I'm not sure if this would affect her insurance because I don't know how that works with a parked vehicle in Canada. But he made the insurance claim and said, I need $500 from you. So she argued that she shouldn't have to cover the deductible because she never agreed to pay anything if he filed an insurance claim. But the tribunal says the note constituted an offer to pay for repair costs, which is what the note said. And so this is important. The note was in writing. She says later they had a discussion. Two different things. We'll get there in a second. So the decision issued says the note was a settlement agreement that the woman could not change without both parties agreeing, entitling the man to the $500 deductible, interest on that amount plus $125 in tribunal fees. So she's out $625 plus a small amount of interest, which would probably run from when he paid the deductible. And so that'd be sometime, I'm guessing, late 2023. So that might add up a little bit, but not a whole lot. But interestingly, I saw some comments under the story. And remember that both of these parties are attorneys. And it sounds like the guy whose car was damaged did what most people would do and said, oh, I'll turn it into my insurance company, or I'll turn it into the insurance company. And then there's a $500 deductible. You pay that. And interestingly, in contract law, there are a couple different concepts that come into play here. And one of them is that, generally speaking, parties to a contract, if they're going to get damaged and they have the ability to do so, they need to mitigate their damages. So I can't sit there and watch some kind of catastrophe unfold and go, I don't care about that because that's somebody else's fault. They got to pay for it, so I don't care. So when somebody says, hey, my car got damaged, I need you to pay for it because you caused it, I can't go, oh, let's go find the most expensive auto repair place on earth and tell them to go nuts. If it's not reasonable, you don't do that. You do what you can to mitigate your damages, to lessen the damages. And so here, a reasonable person would say, well, gee, if I do what I'm going to do right now, she owes me $500. She offered to pay me $2,000. Now, interestingly, $2,000 wouldn't cover the bill because the bill would have been $2,231. So what she offered to pay, the $2,000, was too little. And when he says, all you need to pay is $500, she goes, I don't want to do that because that wasn't our agreement. It's like, wait a second. The other attorney mitigated his damages and got them down to where it's going to cost you $500. Just pay them. And so several people in the comments section are like, I've noticed that both of these people are attorneys, but that attorney who's trying to back out of paying $500 when she offered to pay $2,000 doesn't sound like she's being fair about this. So the one thing I want to point out to you is some people might say, Steve, is that note on the car a binding contract? And I think what the tribunal's getting at, it has the effect of one. It has the effect of one. And now, it is a writing. And so something in writing generally has more impact than something that is not in writing. So if I say I talked to a guy and the two of us agreed on something, and you later talk to the other guy and he goes, no, we didn't. You talked about it. I never even talked to him. Who? I don't even know him. You show him a picture of me. I've never seen him in my life. No idea who that is. However, I come back and I've got a document written in that man's handwriting. And he's agreed to do something, and he handed that to me. And you look at it, you recognize his handwriting. And he admits he wrote it. Which of those is better in court? The one where somebody goes, yes, I wrote that. Those are my words. I put that on paper. Versus, what? Who are you? Obviously, the writing's more important, right? So courts put a lot of weight in things that are put into writing. Also, courts put a lot of weight into things where somebody admits something. There's often referred to as an admission when a party makes a statement where they basically bind themselves in a situation by admitting something. I did it is an admission, okay? And likewise, I will pay for that is an offer of some sort, but the point is that I dinged your door. She didn't say by accident or your car was illegally parked. It appears to be saying, I did this. It's my fault. I'm happy to pay. And so the one thing we do not know if he consulted with her and said, I am going to take it to insurance. What do you think of that? Because if she said, well, I was hoping to pay you less by you not going to insurance, I don't know. But it does appear that the tribunal is saying, look, all we have before us is a bunch of people talking about things that happened afterwards, but it all started with she damaged his car. She left a note saying, I damaged your car, and I'm happy to pay for it. And then the court's now looking at it going, gee, he got it to where you only got to pay $500. And you're unhappy because you wanted to pay $2,000? And that's what a lot of people commented on was, how reasonable is that? That instead of asking her for $2,000, he's asking for $500. She goes, oh, that wasn't our agreement. You wanted to pay more money, and you're deeply hurt that he's asking you for less money? Like what? So I don't know if there's a nuance in Canadian law where that makes any sense. And maybe it is because if she has a claim that got paid that was attributed to her, maybe her rates go up. I don't know. But there's no mention of that in here. But the interesting thing is that what the court has before it is the note. I dinged your car. I am happy to pay. Here's my contact information. That's the note. And then her version is, oh, but I told him I wanted him to do it one of three ways. And the third way that he went with is the one where I'm paying money, but I thought I wouldn't have to pay any money that way. And they're like, no. And so they must not have thought that later discussion, if they ever did have such a discussion, doesn't override the note that simply says, I will pay. And in case you're curious, and I mentioned this earlier about mitigation of damages, saying I will pay is not an open-ended blank check. He obviously can't go out and buy a whole nother car and say, oh, you said you'd pay, so I just did the most expensive thing. I replaced my car. Obviously, you've got to be reasonable in what you do, and the court will enforce the contract as long as the terms are reasonable, and that is reasonable. I'll pay. What are you going to pay? The cost of repair, and the deductible on the cost of repair is even less. So quit your complaining. So Caleb, thanks for sending that. BC ruling says note on dinged car doors, binding contract between two lawyers. Canadian Press published it. Daryl Greer wrote it. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law.
I went to the doctor and he said, I have acute appendicitis. And I said, compared to who?